Yesterday, I interviewed Mandy Olsgaard, who is a toxicologist and works on monitoring the oil sands tailings ponds in northern Alberta. We were talking about a recent spill, 5.3 million liter spill at Imperial Oil's Curls oil sands plant. And one of the points that she agreed with was that Alberta has terrific oil and gas regulation, legislation, policy, and regulation. The problem is that the regulator, the Alberta Energy Regulator, has too cozy a relationship with industry. And very often the regulations are subverted or diluted down on the ground. So I wanted to explore that a little bit more and talk about the conventional side and landowners. And I'm going to be interviewing Mark Dorin, who's with the Polluter Pays Federation and based in Alberta. So welcome to the interview, Mark.
Thanks, Markham. I'm glad to talk about the Alberta Energy Regulator has a very difficult mandate, and it's time we had a conversation about whether they're properly carried out that mandate. So I really appreciate your focus on that topic. It's way overdue.
Well, let's start at the broadest level. Give me your take on the relationship between the conventional producers, the folks who maybe have oil and gas wells on your property, and the regulator. What's your general take on that?
Well, I think that there is access. I've been involved in lots of hearings, etc. There's full access between operator personnel by email, by phone. They're on a first name basis with regulator people that on topics that shouldn't be discussed with the regulator that involve people's land rights and public safety rights unless the landowner copied, and in even topics that probably couldn't even be discussed outside of a formal process. So think of the regulator as a court, a police department, and an administrative body all rolled into one, and they have to keep those functions separate, and they're just not doing it. Part of it is because of the complex structure of the Alberta Energy Regulator, a very unique body with a huge, broad, difficult mandate. These guys have an incredibly difficult job to do. I'm the first to admit that, but they're just not doing it in accordance with law.
Now, Mark, in Alberta, there are hundreds of thousands of conventional oil and gas wells. Many of them are on private property. And there's been a lot of complaints from landowners that taxes don't get paid or fees don't get paid. And very often the way the oil and gas operators are operating on that property and the condition in which they leave the wells when they abandon them is a big problem. Is that a fair take from your point of view?
Well, there's a lot of problems with the use of land by oil and gas and other energy activities, I might add. But oil and gas is probably the worst. They range from trespass to lack of public safety, sites too small, dangerous substances not being kept on site. Abandoned wells means plugged and sealed and cut off below surface. So, walking away from your wells is to orphan a well, really. There's tons of problems with that. Lack of payment. We've got a lot of operators, smaller operators, just sending out half payments to landowners, using landowners like a bank. Landowners don't know what their rights are, so they cash those checks they shouldn't be. We know that municipalities are heavily subsidizing irresponsible operators who refuse to pay their taxes. That's to the tune of $500 million and growing in Alberta. There's also the problem I think nobody knows about in Alberta is when wells are named as orphans, or when before they're named as orphans and the owner is delinquent on payments to the landowner can file through Section 36 of the Surface Rights Act to get payment. The Land and Property Rights Tribunal is supposed to act somewhat like a collection agency, but if they can't get payment from the delinquent operator, they put an order onto the Minister of Environment, which is now Sonia Savage, to pay the landowner. So this is at least $30 million minimum, probably close to double that per year that the taxpayer is paying landowners on behalf of delinquent oil companies. So landowners have always been quiet and mollified because they get payments. and they still are getting payments, but it's coming from the taxpayer's pocket. And I suggest that those payments, we need a change of law to make those payments come from the Orphan Well Fund, from industry's pocket, so that they speed up reclamation of land after wells become orphaned, because there's this huge backlog and it's really costing the taxpayer a lot, but not directly, it's indirectly, so it's not noticed by people.
Now, what role does the regulator play in this, Mark? Because the accusation has been made, I've heard it many times over the years, that the AER is captured by industry, that the relationship is too cozy. There's a bias built in. I mean, Mandy told stories yesterday about, committees, working committees up in northern Alberta to deal with tailings ponds, and she, as a a professional toxicologist, would be excluded from meetings or even forced to leave. To what extent, or maybe I'll ask this question: in your opinion, is the AER a captured regulator?
Well, let me answer that this way: they're either captured or they're incompetent, and it doesn't matter. The end result is the same. So I don't focus so much on why, as opposed to the outcome, and the outcome is unacceptable. And you ask me what their role is. The courts have clarified this, and as far as landowners are concerned, there's two main bodies. There's the Alberta Energy Regulator, if it's oil and gas, or the Alberta Utilities Commission, if it's different activities like power or pipelines, etc., or certain types of pipelines. And the courts have clarified there's this overlapping jurisdiction. They share certain powers, but which body has priority in certain circumstances? And the courts have clarified this. And it's a pretty clear test. You have to read the actual statute, the clause of the statute you're dealing with, and it'll tell you which body has priority. Well, we have this huge finger pointing exercise going on. If you take what the tribunal members say and you go to argue that in an AR hearing, they won't even let you argue it. They have their own mind up. So it's like the AR says that landowners must go to the tribunal. And in fact, most landowners are never involved at the tribunal if it's a private contract on their land. So the AER does everything except compensation. That's the ruling of the court. But your compensation is supposed to be based on your actual losses, the actual risk to you. And landowners at incredible risk. I just went out to some sites yesterday for a landowner. What I saw blew my mind. And I've seen it all really bad. It's incredibly unsafe.
Why did it blow your mind, Mark? Like what?
Regulatory
for us.
Regulatory noncompliance everywhere, trespass everywhere, but mostly lack of safety for landowners. These landowners are farming too close to these sites where there's gas all over the place. It's supposed to be being burned for public safety reasons. Their lives are literally at risk. Their health is at risk. What Mandy said yesterday about people's health being at risk near tailing ponds, this is the case around most oil and gas sites, well sites and other sites across the province, and we have pushing 500,000 of these. The tailing ponds is the tip of the iceberg in terms of lack of public safety, and most of the releases at conventional oil and gas sites in Alberta, they're invisible, tasteless, and odorless. It's called methane or hydrocarbon gases emitting from wells, from tanks, from other sources. We have laws against this that Lougheed brought in 1971, and they used to be adhered to pretty well, but now it's just there's with the sheriff, the regulator doesn't take his gun out of the holster. When the industry knows there's not going to be any repercussions for lack of public safety, they just do what they want.
Now, my understanding is that the bigger companies take their obligations fairly seriously. Would you agree with that? And is it the smaller operators that tend to be the biggest problem for landowners?
Maybe slightly, but I see just as many non-conformances at large company sites as I do at small company sites. And I can tell you this, that if it's a small company, quite often you can talk to the person in charge. Quite often you can get that rectified by talking to them. But if it's a big company, blam, they lawyer up immediately. As soon as they lawyer up, which they do 9 out of 10 times, you have no hope. These lawyers in Calgary will successfully argue in AER hearings that the law does not apply to them and the law does not apply to the AER. There's transcripts that prove it. It's an incredibly bad situation. All of this is available from the AER's website. You just have to know where to find it. But there's so much stuff there and it's so difficult to search that website. But I assure you it's there. I'd love to take a journalist through some of the absolute proof of AER incompetence on their own website. It's everywhere.
Okay, so if I understand this correctly, Mark, there are regulations about what the oil and gas company can do on its lease on your land, right? Whether it's safety, if it abandons the well, if the well is inactive, all of those are covered by regulations. And the problem here, as I understand it, is that the companies, for whatever reason, don't comply with the regulations. And then the AER has the regulatory muscle to enforce it, but it either chooses not to or it doesn't have the resources to. And as a result, the bad actors aren't ever held to account and they aren't ever forced to change their ways. Have I got the argument right?
Yes, although I would add that it's not just law. There's either a private contract that has terms and conditions. They're called surface leases in Alberta, which create unique interest in property. That they're not really leases. It's not really rent. Or there's something called a right of entry order. So if the landowner doesn't agree with the oil company, they can go get a right of entry order from the Land and Property Rights Tribunal, the former Surface Rights Board. So there's terms and conditions of land use as well as law. So there's double up on this, if you will. The tribunal has no enforcement whatsoever. They've just changed the law to allow them to. They could have their own enforcers, but they don't. So it all falls to the regulator. The regulator will usually say, "Oh, that's a private contract matter, so I don't get involved." That they won't even get involved on where the boundaries of a well site are, but they're the ones, according to the courts, that determine those boundaries in the first place. So there are lots and lots of every problem that landowners have. I assure you, there's one or more remedies at law in the written law, but you must make a formal application or a formal complaint asking the regulator to intervene somehow. And if you make certain types of applications formally, they're supposed to be posted on their website. They're supposed to be posted in newspapers, public notice, and they're supposed to deal with them. They don't. They hit the garbage. So, and then sometimes we're talking about human life here, and they won't even accept an application to deal with dangerous things. So let me just say that I've called AR inspectors out, including in urban Edmonton, including at sour gas sites, with sour gas floating across the Anthony Henday Drive, again, at the same site, again and again and again and again. And each time they say, come up with a plan so this never happens again, even in hearings, and it happens over and over and over and over. So, there's just really no way to truly solve these problems for landowners. And so the statutory scheme is that your compensation is supposed to rise when this type of thing happens, but we're at minimal compensation as well. So it's just not working. It's all about balance of rights between landowners and operators. And that's what it's all about. And we have terms and conditions and compensation. Those are the tools to create this balance. None of it's working for landowners.
Okay, let's finish up the interview with this question, Mark. So the oil and gas has made Alberta quite wealthy. It has the highest per capita income in all of Canada by quite a margin, and the accusations have been made that the government would prefer to see that development and see that wealth flow into Alberta more or less unimpeded, or as little difficulty as possible. And so at the regulator, there's the expectation is that the economic interests of the companies are more important than some of the other considerations like landowner rights. But the industry is fond of saying that it complies. We have the best regulatory system in the world, and they comply with it to the letter. So how do you respond to the skeptic that says, oh, you're just talking about a couple of, isolated incidents? The industry far and away, as a whole is compliant, and the regulator does a good job. How do you respond to that?
Well, I respond to that it's just simply not the case. I've got almost every time I go to the regulator with serious matters. These are serious matters. There's nothing ever happens. So I agree that we have possibly the best laws in the world. I would say that we could use a little tweaking here and there, especially with how these different bodies are supposed to work with each other, because one of the biggest problems is the two different bodies landowners have to deal with pointing. It's called refusal of jurisdiction. They all say that's the other guy, and nothing. Your issue falls into what I call a jurisdictional black hole. So it's just not true. They say we're the most ethical. By far, we're not the most ethical. I've worked all over the world. I spent a lot of time in the Middle East. These wells in there, they're primarily way out far in a desert or somewhere where people aren't living and farming next to them. We have wells in almost every urban location in Alberta. Urban oil and gas is in a terrible state in Alberta, absolutely awful state. And so we have people working and farming around these sites. They're not informed. The licensee and the regulator is supposed to make sure the licensee properly explains the nature of the operations to these landowners and the rules. It's not happening. These landowners have no idea the risks they're exposed to. It's incredibly bad. We are not ethical oil producers, far from it. We should be the best. We can be the best. We have the best laws to be the best, but we're not, and that makes us the bums of the world. So we need to fix that. It's election time. We need AAR reform in the worst way. These liabilities will be passed on to the landowners if the AAR doesn't enforce these laws. We can't afford it financially. We can't afford it from a health standpoint. We can't afford it from a land rights standpoint. So we need to reform the AAR. It's that simple.
Well, Mark, thank you very much for this. Really appreciate your insights.
Thanks for having me, Markham.